Joseph Obalde po from Interaction.com. Any reaction from Twitter comments saying that you only appear before the Senate impeachment court to fight the prosecution, but not necessarily performing your task as a senator judge?
Provocative yan. In-explain ko naman may hypertension ako eh. Katanungin mo ako ng ganyan, na-open naman ako. Next question. Huwag tayo baiting. You're baiting me.
Ma'am, based lang po yun sa Twitter po na...
Kaya ano naman sino si Twitter? Senador ako si Twitter ba naman ang kalaban mo sa akin?
So, answer from DCRH, satisfied na po ba kayo doon sa pagpapaliwanag lang ng mga defense lawyers na sa allegations that senators received 100 million or offered a bribe for 100 million? Yung pag-i-explain lang sila para hindi sila ma-cite in contempt. Satisfied po ba kayo doon?
Well, they were ordered to show cause why they should not be cited for contempt. That means that their explanation was not considered acceptable by the impeachment court today. For one thing, we want to question why they had to hold that press conference. Was it a matter of life or death? Or was it a matter of survival of the defense panel? Why does that have to be broadcast when there is no tangible evidence? Apparently, the allegation is that they heard. So it's hearsay evidence. They heard that all or some of the senators would be offered 100 million pesos worth of soft projects if they voted to disregard the Supreme Court TRO. So basically, if you examine it, the fundamental reason for calling a press conference is to convey hearsay information, which incidentally is derogatory to the impeachment court. I have to remind the public that according to the rules of court, anything that degrades the administration of justice constitutes contempt. So, you know, people would have been impelled to speculate which senators are these, and are they all covered by this warning to the public, or are there some who were not approached, and so on. It sets up an entire chain of speculation, which is derogatory to the court as a whole.
So follow-up lang, ma'am. For the record, nag-text po kayo na hindi kayo tumanggap or hindi kayo natawagan ni Luman. Pati for the record lang po.
Yes, I was asked, and I said I have not been contacted in any manner, form, or shape, and much less I have not been offered any 100 million, either in cash or in any other amount, and including any other inducement with respect to my vote in today's caucus.
Ma'am Kay Imson po from TV5. Ma'am, kanina po yung ibang senator judges, very vocal po sila about dun sa stand nila sa pagbibigay ng reaction nila tungkol sa ginawa po ng defense kahapon. Ma'am, personally kayo, nung napanood niyo po yung press con na ito, ano ma'am yung naging reaction po ninyo?
The press con here?
Yung press conference po, yung mga sinabi po ng defense yesterday, nung nalaman niyo po yun, ano po yung naging initial reaction po niyo?
Well, if I were still a presiding judge in trial court, if that had happened to me, I would certainly ask the lawyer to show cause why I should not cite him for contempt. Why does he bring the trial outside of the courtroom? That is completely forbidden under the rules of court. You cannot litigate outside. You cannot try and shape public opinion that might be derogatory to the judge or to the court. That is the rule. So, I can understand if they were about to be assassinated, then they can hold a press conference and say, we heard that they're about to be assassinated, but if it's just a question of giving money, I do not see what the urgency is. They could manifest it in open court if they feel very strongly that they have to reveal it for some reason or other. But why hold a press conference? That is normally never done in trial court. You never hold a press conference about a case that is still pending. Afterwards, you can, of course, exercise your right of free speech and either praise the judge or condemn him.
Hi ma'am, Sante from GMA. Ma'am, do you share the view of some senators that the defense panel should name their source for the allegations that they made regarding the supposed alleged bribe attempt?
No. I don't think you can force any person to reveal his source. This rule, of course, applies to media, but for humanitarian considerations, it should be made applicable to all. Because, you know, there might be serious considerations of physical safety or personal security involved.
Ralph Rivas po of IBC 13. Ma'am, I'd like to know po your opinion regarding the growing perception that both the prosecution and the defense are showing their ammunitions outside the court. And if so, what should be done?
Yes, this is very serious because, in effect, we are conducting two parallel trials. One is being conducted inside the courtroom, and one is being conducted on the platform of mass media. We all know that this should not be done, but in the impeachment court, we are treading on very, very thin ice if we issue a gag order against both panels, because that might infringe press freedom. That is the reason why we are so careful not to admonish either side from talking to the media, because the media itself might feel that we are targeting them, which is not our intention. So we have to trust only the good faith of the media. If it exceeds perhaps a certain limit, perhaps then the court might issue a statement, but we will not gag the media and the sources of media unless there is irreparable damage being done, or if there is manifest injustice being done. Normally, the remedy for trial by publicity is, as the Constitution provides, to move the venue to another place where the media is better at looking at the facts than in that one place, where there's been trial by publicity, not only to the media, but also by, for example, demonstrations, rallies, and so on. So normally the remedy there is to ask for a change of venue, but that is not available in this present instance.
Ma'am, good afternoon. Paula Palma from Solar News. Ma'am, do you share the sentiments of the other senator judges when they said that it's one of the tactics of the defense to derail the impeachment trial?
Who said?
Some of the senator judges.
Well, that is the job of the defense. The prosecution and the defense are called advocates. You have to fight tooth and nail for your client. That is why the court is very patient with some tactics employed. We are all familiar with this: harassing the witness, or objecting too many times in quick succession to the counsel who is conducting a direct examination, so that he will get unnerved and he will lose his focus on his line of questioning. These things, we are very liberal with them because they are simply carrying out their role as adversaries. They're not merely lawyers and servants of the court. They are supposed to be the champions of their clients. It's like, you know, as if they were knights jousting. And that's exactly how the law profession was created. Since during the Middle Ages, they settled issues and conflicts by picking two champions who would ride against each other and try and kill each other with their lances. They decided eventually that that was too physically exhausting, and therefore they invented lawyers who, instead of riding horses and using lances against each other, would instead argue in front of an impartial